Every single day, millions of people enter into legally binding contracts without signing a single piece of paper. In fact, you probably did it this morning. That cup of coffee, that app download, that online order, all contracts. And when something goes wrong with one of those transactions, the rules that govern what happens next fall under a very specific area of law called sales contract law. Stay with me, because by the end of this video, you're going to understand exactly how sales contracts work, what makes them valid, what happens when they fall apart, and how these rules protect you, whether you're a buyer, a seller, or a business owner. Let's get into it. Section 1. What is a sales contract and where does the law come from? A sales contract is a legally binding agreement where one party transfers ownership of goods to another party in exchange for payment. Simple enough, right? But here's where it gets interesting. The law that governs most sales contracts in the United States isn't one giant federal law. It's actually a set of rules called the Uniform Commercial Code, or UCC. The UCC was created to make commercial transactions more consistent across all 50 states. Think about it. If you're a business in Texas selling products to a company in New York, you need both states playing by the same rulebook. The UCC does exactly that. Now, one critical thing to know, the UCC specifically covers the sale of goods. Goods are movable, tangible items, cars, furniture, electronics, clothing. It does not cover real estate, services, or intangible property like patents or stocks. So if you're buying a house, that's a different area of law entirely. If you're buying a laptop, UCC applies. This distinction matters more than most people realize, and here's why. The rules under the UCC are actually more flexible and business-friendly than traditional contract law, which raises the question, what exactly makes a sales contract valid in the first place? Section 2. The elements of a valid sales contract. For any contract to be legally enforceable, certain basic elements need to exist. Under the UCC, a sales contract requires an offer, acceptance, and consideration, which just means something of value exchanged on both sides, usually money for goods. But here's something fascinating about the UCC compared to traditional contract law. Under traditional rules, an acceptance has to mirror the offer exactly. Any change, and you've got a counteroffer, not a contract. The UCC throws that out the window with what's called the Battle of the Forms rule. Under UCC Section 2 to 207, if a merchant sends back an acceptance with slightly different terms than the original offer, you can still have a valid contract. The different terms just become part of the negotiation. This matters enormously in business-to-business transactions, where purchase orders and invoices often have pages of fine print that never perfectly match. The UCC also relaxes rules around price. If parties intend to make a contract but leave the price open, a court can fill in a reasonable price. Same with delivery terms, payment schedules, and more. The law essentially wants to support commerce and keep deals from falling apart over technicalities. But wait, does a sales contract always have to be in writing? That answer might surprise you. Section 3. The Statute of Frauds and Written Requirements. Here's where a lot of people get tripped up. Under the UCC's version of the Statute of Frauds, any sales contract for goods worth $500 or more must be in writing to be enforceable. That $500 threshold is lower than most people expect, and it catches a lot of informal deals off guard. Now, the writing doesn't need to be a formal legal document. It just needs to indicate that a contract was made, specify the quantity of goods, and be signed by the party being held to the agreement. An email, a text message, even a purchase order can qualify. But there are exceptions. If a merchant receives a written confirmation of a deal and doesn't object within 10 days, that confirmation can be binding on both parties, even without a separate signature. This is called the merchant's exception, and it's why businesses need to actually read their mail. Other exceptions include situations where the buyer has already accepted the goods, where the goods are custom-made and can't easily be sold elsewhere, or where the party being sued admits in court that a contract was made. So writing protects you, but it's not always required. What happens, though, when one of the parties doesn't hold up their end of the deal? Section 4. Performance, Breach, and Remedies. Once a valid sales contract exists, both parties have obligations. The seller must deliver conforming goods, meaning goods that match exactly what was agreed upon. The buyer must accept those goods and pay for them. Under the UCC's perfect tender rule, if the goods delivered don't conform to the contract in any way, wrong quantity, wrong color, defective quality, the buyer has the right to reject the entire shipment, accept all of it, or accept part and reject the rest. Now, sellers do get a chance to fix their mistake. This is called the right to cure. If a seller delivers non-conforming goods before the delivery deadline, they can notify the buyer and make a proper delivery within the contract time. After the deadline, cure is sometimes still allowed if the seller had reasonable grounds to believe the non-conforming goods would be acceptable. When a true breach happens, meaning one party just doesn't perform, remedies kick in. For sellers, remedies include stopping delivery, reselling the goods to someone else, and suing for the difference in price. For buyers, remedies include canceling the contract, getting a refund, purchasing replacement goods from another seller, and billing the difference to the breaching seller. That's called cover. Or, in rare cases, demanding the specific goods themselves through specific performance. The UCC's goal with remedies is always to put the injured party in the same position they would have been in if the contract had been performed. Not punishment, restoration. And that philosophy leads us to one final, critically important concept. Section 5. Warranties in sales contracts. When you buy something, you're often buying more than just the physical item. You're buying a promise about what that item will do and how it will perform. That promise is called a warranty. There are three main types under the UCC. First, express warranties. These are explicit promises made by the seller through descriptions, samples, or direct statements. If a seller says a car gets 40 miles per gallon, that's an express warranty. Second, the implied warranty of merchantability. This automatically applies to any merchant seller and guarantees that goods are fit for their ordinary purpose. A blender should blend. A raincoat should repel rain. No one has to say it out loud. It's implied by law. Third, the implied warranty of fitness for a particular purpose. This applies when a seller knows a buyer needs goods for a specific use, and the buyer is relying on the seller's judgment. If a store employee tells you this specific paint is safe for outdoor metal surfaces and it's not, that's a breach of this warranty. Sellers can disclaim warranties, but they have to do it clearly and conspicuously. The word "as is" can eliminate implied warranties. But courts look closely at these disclaimers to make sure they're fair and noticed. And there you have it. Sales contracts aren't just boring legal paperwork. They're the framework behind virtually every commercial transaction in your life. You now understand what makes a sales contract valid, how the UCC differs from traditional contract law, when you need things in writing, what happens when contracts go wrong, and how warranties protect you as a buyer. If this video helped you, do me a favor. Hit that like button, it genuinely helps this channel grow. Subscribe so you don't miss the next chapter, and drop a comment below with any question you still have about sales contracts. I read every single one. See you in the next video.